Good evening. Welcome everyone to our conversation tonight about some of the legal implications of recent court cases and some of the other actions going on in federal government. My name is Jenny Mattingley. I am the Vice President of Government Affairs at the Partnership for Public Service, and I'm thrilled to be doing this webinar tonight with our friends from Civil Service Strong, from the Rise Up Federal Worker Legal Defense Network, and from AFGE, and they'll introduce themselves momentarily. But for those of you not familiar with the partnership, we're a nonpartisan nonprofit working to build a better government and stronger democracy. And we do that through advocacy, leadership development, workforce programming, and really convening conversations like this to help you make sense of all of the things that are going on right now that impact both current and former federal employees. And so we will throughout give some resources in the chat, so please look for those and talk through your questions as well. But before we get started, I just want to thank those of you who have served and who had to leave government. Thank you for your service. Thank you for your commitment. And I know we are all here to support you as best we can. Before digging into the conversation, a couple quick housekeeping items. Throughout the webinar, please feel free to submit a question through the Q&A function, and we'll do our best to answer what we can. If you would like a question to be anonymous, please be sure to click that checkbox before submitting your question. We also appreciate all of you who have submitted questions in advance, and we'll do our best to get through those. But given the complexity and nuances of the topics we discuss, we may not be able to address every question tonight, but we can certainly hold more webinars. Please be on the lookout for those. And there are places that for each of our organizations, you can ask questions as well in the future. And if you miss anything we've discussed tonight or want to revisit it, this is recorded. It'll be on our websites. And so you can certainly, on our FedSupport hub, I know all of our partners here tonight will have it as well. So you can certainly go back and look at those. And before we move on, I just will highlight a FedSupport LinkedIn post that compiled a bunch of resources from partnership, from our other organization that we work with that have resources on RIFs, reassignments, changes to employment status. And I know our guest tonight will also be putting related items in the chat for you. So final thing, moving on to introductions. Would love for our partners tonight to introduce themselves. And Rob, why don't we start with you?
Thanks, Jenny. It's always an honor for me to get a chance to talk to federal employees, current and former. So thanks for doing this tonight. It's great to be here. I'm Rob Shriver. I'm with Democracy Forward, and I lead our Civil Service Strong program. So for those of you who may not be familiar with us, Democracy Forward is an organization that goes to court for people and democracy. We've been very active in litigation on behalf of federal workers against RIFs and other things the Trump administration has done. Civil Service Strong is a program of Democracy Forward that provides support to not only our litigation teams, but to federal workers like yourselves through webinars, through resources on our webpage, through working with a broad coalition of organizations that exist to support feds. Before I came to Democracy Forward, I spent the entirety of the Biden-Harris administration at OPM, with the last 8 months as the acting director of OPM. Thanks again, Jenny.
Thank you. Rushab, you're next on my screen.
Thank you, Jenny, and thank you all for attending. I am Rushab Sanghvi. I'm the General Counsel of the American Federation of Government Employees, or AFGE. AFGE is the largest federal sector labor union. We represent over 800,000 federal employees at agencies across the country, from the Veterans Affairs Administration to NASA. We have been actively advocating for federal employees, not only for our members, not only for those who we represent, and have partnered with many organizations, including Democracy Forward, to litigate on behalf of our members. And we continue to represent our members and federal employees through nearly 1,000 affiliate unions. Many of you may be members of those affiliates as well. So happy to share our thoughts and share what AFG is doing. And again, thank you to the partnership for putting this together, and thank you all for attending.
Great, thank you. And Deborah, over to you.
Good evening, everyone. I'm Deborah Greenfield. Currently, I'm the Executive Director of Rise Up Federal Workers Legal Defense Network. Um, I have spent my entire career as a lawyer advocating for workers. I started out as a union lawyer. I've worked for the AFL-CIO, but I have also spent many years, both as a career employee and as a political appointee in the federal government at the US Department of Labor. And it was really my pleasure and my honor to work alongside so many amazingly talented and dedicated and smart colleagues at the Department of Labor. So what's happening now does feel very personal to me. As I said, I'm the executive director of Rise Up. We launched in April of this year, and we match federal workers who've either been terminated as a result of what's going on now by the actions of the administration, or who have employment concerns, who may still be employed, but who have concerns about their ongoing employment. We match those federal workers with volunteer lawyers who provide a 1-hour consultation to the worker to help figure out what that worker's options are, what that worker's rights are, and then what their legal options are, according to what really their own goals are. And so we, in a sense, complement the incredibly creative and powerful impact litigation that our partners, including Democracy Forward, are doing by providing what we call the retail version of legal representation. So I work very closely with Rob. I work closely with AFGE, with Rushab and his team, and I'm delighted to be here tonight.
Great, thank you all. This is a great group to have this conversation with, to answer questions. The goal for everybody listening in tonight is to really provide you info about a recent Supreme Court ruling, share some practical information for federal employees navigating RIFs and other actions, and highlight some resources available. Just a quick side note, this is all general information. It's not legal advice. And so should you have specific questions to you, that things you're working through, there's a lot of resources and attorneys out there who can help you navigate and answer those particular questions. So we will dive right into the conversation, because I can tell we are already getting questions from folks in there in the chat Q&A function. So to get us started and set the stage, Rob, Deborah, can you talk to us, Rob, give us an overview of the Supreme Court case, and, all of you I invite to jump in and talk about, what it means for federal employees, what's still unclear, and what else is coming down the pipeline. So why don't we start? That's a big opening there. Why don't we start with that, and feel free to all jump in.
Yeah, thanks, Jenny. And thanks for indulging me for a minute here, because this is confusing stuff. And I want to kind of make sure to level set with everybody about what the Supreme Court decision did and what it didn't do. So the decision was issued back on July 8th. And I've seen several questions about this case and about the authority of an administration to reorganize the government. So let me just start by saying that, Democracy Forward, with a bunch of partners, filed a big lawsuit to challenge a bunch of RIFs happening across the government. And at the heart of our claim is the argument that really these RIFs are evidence of a reorganization of the federal government that Trump-Vance administration is carrying out unlawfully. And in the process, they're dismantling federal agencies through mass layoffs, agencies closures, and other reorganization tactics. So that was the essence of our lawsuit. It all sort of came about because of President Trump's Executive Order 14210 that directed federal agencies to implement mass layoffs and reorganizations without any congressional approval. We think that's wrong. We think that's executive overreach, and it violates the Constitution's separation of powers and federal law, including the Administrative Procedure Act. We think that Congress, not the president, has the sole authority to restructure government agencies. That the administration is carrying out these changes without congressional authorization, harming federal workers, and of course, all of the communities that federal workers serve. So thousands of federal workers have already lost their jobs, their benefits, and their stability. And as you all know, there are more layoffs on the horizon. Public services like healthcare, veterans care, environmental protection, and education programs are being gutted. This is hurting people and communities across the country. And again, we think it is a blatant abuse of executive power that undermines democratic checks and balances. So the named plaintiff in the lawsuit is AFGE, Rushab's union. We've worked with unions and nonprofit organizations, local governments to challenge this power grab, and we tried to block it. And we were blocking it for a while. The federal district court initially blocked the administration's plan and found it likely unlawful. And the circuit court agreed. So we got a favorable ruling at the district court level. The government appealed, favorable ruling at the circuit court. Then the government went to the Supreme Court. And on July 8th, what the Supreme Court did is they essentially blocked the lower court from blocking the administration. So they have that for a double negative for you. But basically, they said that, you know, the district court could not stop the administration from moving forward with its actions while the case continues to be litigated. So let me be clear. The legality of the administration's reorganization efforts continues to be subject to litigation. All the Supreme Court did was say that the district court's order blocking the administration from moving forward, that was going to be stayed while the case progressed. What makes this particularly annoying, in addition to being like, you know, just so traumatizing for federal workers, is they did this through their shadow document, their shadow docket, the shadow docket. And so, you know, that's sort of like a shortcut that the Supreme Court uses sometimes, and it doesn't necessarily result in the most well-explained decisions. So again, I want to emphasize the court did not rule on the legality of the executive order. It did not rule on the legality of the reorganization plans themselves. It temporarily paused the lower court's decision. So the case still is being actively litigated. And let me just one more thing here real quick, Jenny, because I think there's a lot of questions about who's all covered by this. So there were over 20 agencies that are impacted by that Supreme Court decision. It applies to agriculture, commerce, energy, parts of HHS, HUD, the Interior, Labor, State, Treasury, Transportation, and Veterans Affairs, as well as AmeriCorps, the EPA, GSA, the NLRB, the National Science Foundation, Peace Corps, Small Business Administration, and Social Security Administration. I'm going to drop a resource in the chat here that outlines all of those. So you see it's a big chunk of the government, but not the whole thing. I'll just pause there, Jenny.
Great, thanks. Deborah, Rushab, any comments to add in?
Let me just say that this is a real question of not being able to put Humpty Dumpty back together again, because what was at stake here was that while the lower court was deciding whether the administration has the authority to do this sweeping reorganization of the federal government, that lower court said, we're not going to let the RIFs and the reorganization plans go into effect yet. We have to figure out first whether they're lawful. If the government can go ahead with them while we figure this out, you can't really put the pieces back together again. And when it reached the Supreme Court, all bets were off, and the Supreme Court said, well, we don't think that there's reason to prevent these RIFs and reorganization plans from going into effect while the lower court figures out whether this is legal. So what you have is a scenario now where agencies are making decisions about how to move forward with their RIFs and reorganization plans. It's possible that the lower court will say, oh, but these plans are unlawful. What do we do at that point? People's lives, which have already been upended, will have been upended again. Are we going to put the pieces back together, recreate the agencies, it's not only confusing, but it has been so destructive of people's lives, of families, and communities. So we're in a very, really a very destructive situation, made worse by what the Supreme Court just did.
Rushab, I think you have some thoughts too.
I just wanted to sort of like talk about two quick things. So one, on the Supreme Court decision, I think it is important to note that the Supreme Court noted in its decision that it wasn't commenting, it explicitly said it wasn't commenting on whether or not any specific agency reorganization was lawful or not. It was only talking about the executive order itself. And again, as Rob said, this is all sort of a temporary, right? This was a pause on a pause. And so the litigation does continue below. The other thing, to note, because we get this question a lot, is that the Supreme Court's decision in this case, AFGE v. Trump, which originated in the Northern District of California before Judge Ilston, the Supreme Court's decision there only applies to that case. There are overlapping injunctions and cases that are out there that were not directly affected by this decision. So I just wanted to note that. And I know some of the practical effects we'll get into as we continue to discuss.
So the takeaway, I think, for folks, and I'm seeing some of this in the questions, is that there are a lot of lawsuits still out there, ongoing, both ones that affect the 20 agencies that Rob mentioned, and then other lawsuits as well on related RIF or reorganization issues. So people should be keeping an eye out for things. And to Deborah's point, it makes it confusing. It makes it really tough to know a timeline. I know folks have asked about timelines that they should keep following, but some of these are going to be ongoing and long timelines. We do have a clarification question coming in about, can you distinguish between the federal court lawsuit plaintiffs from the individual and class employment cases? So I think, what's the difference between sort of who are in the one case versus some of these other class action?
Yeah, so I can jump in there, Jenny. So our community is trying to help folks through all the various pathways where you can seek a remedy. So we bring these district court actions whenever we think we can. It can be hard for federal workers to get into district court because there's long-running case law that basically channels federal workers to the MSPB or the grievance arbitration process or the Office of Special Counsel for employment-related concerns. What you see us doing is arguing that what the administration is doing is so different and unprecedented and raises so many new legal questions that long-standing channeling case law doesn't necessarily apply. And we're also finding that there are people outside the federal government who are hurt by these decisions that help us get into court. So we're doing that wherever we can. But we also, as a community, have been working to bring RIF appeals through the Merit System Protection Board. And, there are law firms that specialize in those kind of complaints, those appeals. Also, you should know that if you're a RIF employee and you're in a bargaining unit, you got to check with your union first, because under the contract, it might be the grievance procedure is the only remedy, and Rushab can talk about how unions are helping there. So just because there is a district court, that's the bottom line I want to draw, is just because there's a district court case that is against your agency and may affect you, you may also have an MSPB appeal. And I think Jenny will talk a little bit more about that later on, but keep your eye on that, an MSPB appeal or a union grievance as well.
And Rushab, that's a good segue into one of the questions that I think folks have, is that union process and how that might be different if they're a union employee or in a bargaining unit versus some of these other cases.
Yeah, and just sort of, just sort of add more confusion into the mix, right? Because this process is confusing. there are several sort of overlapping ways we are making claims, right? And so just sort of an example, AFGE is on a lot of litigation. We've been making claims in federal court with so many partners, but then our affiliates have also been filing grievances over RIFs, and we've also been helping different members file MSPB appeals over RIFs. I think one thing to think about as employees, however, one big picture thing is, you should always keep track of the litigation, and it's hopeful that the district court, federal court litigation will assist and help, and we'll get more relief through that. But as a federal employee or a former federal employee who's subject to RIF, you should make sure that you are actually looking at your administrative remedies as well, because whatever happens in that federal court litigation, you don't want to miss any deadlines or any ability to make an administrative claim that you may have to make on your own. And so I think the first place to look is if you are a member of a union, whether it be an AFGE affiliate or another, is to ask your union what they are doing, what they are recommending, and what your options are as a union, as a member of an employee covered by a union. Because as Rob said, the regulations are complex. But one sort of tricky regulation is that if you are in a collective bargaining unit, so if you are represented by a union and your collective bargaining agreement allows the union to appeal your RIF, then you actually are not allowed to go to the MSPB. You have to go through the collective bargaining process. But it's complicated because in some units, the bargaining agreements say you can't appeal a RIF, in which case, even though you have a union, you still have to go to the MSPB.
And just to clarify on that union point real quick, I get this question from folks. Are they covered by the bargaining unit even if they aren't a union member? And so would those rules apply to them?
That's correct. So if you are in a collective bargaining unit, you're covered by that collective bargaining agreement, irrespective of whether or not you pay dues to the union. Again, another really confusing issue is the administration has attempted to take away union rights from over half of the federal government, right? So that adds another layer of complexity, and so it's always important to get, again, if you are in a collective bargaining unit, to reach out to your union, and if you don't know, to try and find that out. You can go to our website, afge.org, to see if you're in an AFGE unit, and there are other resources as well to find that out.
And Deborah, I know you've got a thing, but just I'll plug real quick. You can look on your SF50, I believe, to figure out. Deborah, go ahead. You may have been jumping in with that.
Well, on another point, but yes, you can look at your SF50, and there's I think it's your BUS code will tell you whether you are represented by a union or not, and then you can find out which union that is. If you are not represented by a union, or if your union contract doesn't give the union the authority to file a grievance about RIFs, then you can file what's called an appeal or a challenge of your RIF directly to the Merit Systems Protection Board under the federal regulations. But be careful, because you only have 30 calendar days from the effective date of your RIF or the date you received notice, whichever comes later. You can't file before the effective date because you'll get kicked out. So normally you're going to file 30 days after the date you're actually, in essence, disconnected from the federal service, and you stop receiving payment. Now, your RIF notices, because nothing is simple right now, are all over the map. You may fall into one of the following categories if you have received a RIF notice. So you might receive, now that agencies have been given the green light to go ahead with the RIFs, you might receive a new RIF notice with a new effective date, and your 30 days will run from the new effective date. The agency might not issue a new notice, but inform you of a new effective date, in which case your 30 days runs from that new effective date. Or the agency may RIF you right away on the ground that you've already received a termination notice and the date has already passed and you're gone. So these are very complicated situations, but you need to pay attention to the status of your RIF notice.
And Deborah, that's hitting, and Rushab, maybe you're going to get to this. It's hitting on a question that we're getting a lot in the chat, but that I've heard from others too in service currently, is that because agencies issued RIF notices, then it got paused because of that ruling, lower court ruling. Now the Supreme Court has ruled. What do they do? Because the 30 days passed from that original notice. Can they still appeal? And Rushab, I don't know if you have thoughts on that.
Yeah, so again, and I think one of the things that makes this difficult is every agency is doing things differently, right? I think Deborah went over some of the buckets, right? At some agencies, employees were informed that their last day would be June 6th, for example. But the agency was enjoined, they were stopped from separating someone on June 6th. Now, the Supreme Court has said, hey, you can go ahead. But the agency hasn't still separated the employee, right? The employees at some agencies haven't received any word of what's going on. But then again, as Deborah said, in some agencies where, someone was supposed to be separated on June 6th, for example, the day after the Supreme Court decision came, employees got notices saying you're being terminated effective today, based on the notice you received in May. So the date that's key again is the date you actually are separated. And that is the date that you should file you have your 30 days starts running. However, you should again consult with your union, and you should again look at your notice, because the MSPB hasn't specifically said yet what happens to those people who, what if they received a notice saying they would have been separated on June 6th, did their time frame for filing start running on June 6th? There's really no clear decision from the MSPB on that. So sometimes it may be worth filing your appeal earlier than you think and then getting kicked out as being premature and then refiling. But again, this is going to be a really individual determination that's going to have to be made. And again, it's really, if you have a union, I would consult with them, because again, they can assist you. And if you don't, it could also be helpful to see if the union that represents other employees at your agency may have some guidance that they can provide as well. Because I know that, not only AFGE, but other unions as well have been trying to help employees who may not fall within a bargaining unit, but are still covered or employees of the agencies they represent employees at.
And I think, go ahead, Deborah.
I think we should say one more thing about or at least one more thing about the MSPB and the status of the MSPB now. As many of you know, there are a number of labor agencies that lack a quorum, which means, and that's being challenged, but not all that successfully in court. If you file an MSPB appeal, you need to, you will be asked to go through exchanging documents that you think prove your case. It's called discovery. You'll be put on a calendar, and then your case will be heard by an administrative judge. But the one level up at the MSPB can't hear cases at this point because there aren't enough members of the MSPB to do that. So this is a kind of hurry up and wait situation. It's very labor intensive, but perhaps but also very long and drawn out at this point.
That's a good point. And Rob, I know you followed a lot of this, and I think it's worth repeating for folks that I saw you put a resource in the chat around self-filing, because I know it's hard sometimes to find an attorney, and they've got the Rise Up network where you can get some initial guidance, but there are other things that people should be thinking about as they do this. And I think class actions come into play and some other things. So
Yeah, thanks, Jenny. So, right. So, like, one big takeaway for everybody is if you get a RIF notice and you're in a bargaining unit, whether you pay dues to that union or not, go to your union rep. If you're not in a bargaining unit, you heard Rushab say that some unions are still trying to help non-bargaining unit people, but you also have Rise Up where you can at least get free legal consultation. I put a resource in to help you file your own MSPB appeal. Filing the appeal itself is not hard. It's an electronic form. It's pretty easy. And then it gets harder after that. And one of the strategies that we've attempted to employ, but it hasn't been working too great so far, is to bring the equivalent of a class action lawsuit at the MSPB. So there have been several efforts to bring like a RIF appeal on behalf of an entire group of employees at an agency or an entire agency. And the administrative judges that Deborah mentioned have, for the most part, been declining to certify those cases as class actions. So what does that mean for you? Well, what we were hoping to do was set it up so that you all didn't have to file your own individual appeals, that you'd be covered by these class appeals. Since that's not happening so far, I would go back to Rushab's point. Check out the notice, and it doesn't hurt to file that MSPB appeal. The worst thing that can happen is they'll kick you out as being premature, or they'll say you're in a bargaining unit, you got to go the grievance route. And there's no harm to you in that. There's more to come here because the MSPB also has a consolidation process. So we're hoping that as these appeals progress, the MSPB will consolidate the appeals. That means hear together, like in one case, all of the appeals from similarly situated employees, which might be, from everybody who's gotten the same kind of RIF notice at an agency, or a group of employees at an agency, so that there's some efficiency in how those appeals are handled. And those of us who are representing you all in these kinds of actions are trying to figure out how to do it most effectively and efficiently. So my guidance right now is you get a RIF notice, figure out, again, whether you're in the union route or in the MSPB route, and don't miss a deadline. File your MSPB appeal because it's pretty easy to do.
And Rob, and I don't know if this is a question to you or Deborah or Rushab, but people are asking whether if they file, say they self-file at MSPB, will it affect their severance pay, and will it affect their status of being on a reemployment priority list if they were to file a appeal?
So I'm going to drop a resource in on severance pay. You have a right to vindicate your legal rights, and if they've messed up the RIF, you have a right to an appeal, and that should not cost you your severance pay. The other question was about your position on the reemployment list.
Yeah.
Yeah, I mean, I don't know if Rushab or Deborah has a different perspective on this, but to me, it would be sketchy for an agency to essentially penalize you by taking away rights that you have under the law because you think they messed up the RIF and are challenging it. I don't think they can take that away from you.
I don't believe so, Rob. And I did want to make one quick note on the class appeals, though. Again, like Rob said, don't miss deadlines, and hopefully none of you have missed deadlines. But one thing to note about if a class appeal has been filed and you were potentially covered by that appeal, the MSPB rules provide that everyone in the potential class, if the MSPB denies certification, so if the MSPB says, hey, this appeal can't go forward as a class, everyone who would have been covered by that class gets another 35 days to file their appeal. So again, don't count on that. Don't count on there having been a class on your, that would have covered you. But it's important to know that if a class appeal has been filed that did cover you, maybe your timeline to appeal may have been extended. So that's just something to keep in mind. And then one more quick note on other things we're doing. I can tell you one thing that AFGE plans on doing with some of our units is trying to get appeals consolidated, but also to provide information to individuals in a specific agency about how they can move their appeals forward, giving sample documents and so forth. That's something our affiliates are going to be doing as we go further on this.
And a clarification question that came in on the class action is whether you have to choose individual versus class action, and that if you file individually, it automatically eliminates any other class appeal if that comes. And so whether if they choose one path or the other.
I mean, I think what usually happens is if the MSPB were to grant a request for a class appeal, they would then, I suspect, provide notice to everybody who's covered by that class, and you would be given the opportunity to say, I don't want to be in the class, I want to pursue my own individual appeal, or say, I do want to be covered by the class. And then your individual appeal, I assume they would likely say you would then withdraw it because you're covered by the class appeal. That's how I think it would work. We're still waiting to see how that plays out, but that's how I think it would work.
And I think I believe they're in the regs, it talks about an opt-out system. So you would have to opt out.
Got it. And one final class clarification question that's coming in, or maybe not the final one, but one I have that we're seeing is, how do people know when either these class or these bigger lawsuits that cover multiple agencies, how do they know when these have been filed? Or if, say, they don't have an appeal, but they're covered in under that same class, where would they go to know any of that information? I don't know if you all, I know it's tough to find all this.
I think, and Rob probably has a lot to say on it, especially on what the community is trying to do. But I think, unfortunately, right now, there's really no repository for the filed classes. Like, there's no website you can go to that will say, hey, these class appeals have been filed. So word of mouth is one way to ask others at your agency if they've been filed. And I think, so that's where we are, but I don't know. I know, Rob, I know you've been thinking about this a lot.
Yeah, I mean, like, anybody can file an appeal anywhere in the country, basically, and ask that it be treated as a class appeal. And we are like, and the MSPB is not like a court when it comes to publicizing to the world via its website all of the cases and everything. So I think the advice I gave previously also applies to this, which is, if you're with the union, check with your union. If you're not, you can check with Rise Up. We try to keep, and Deborah can speak to this, we try to keep the Rise Up lawyers up to date on the cases that we know about. In the meantime, the community continues to work on whether there's a better way to do that. But Deborah, I didn't know if you wanted to add anything there.
I think the only thing I would add here is that if you're trying also to keep track of the federal court litigation, there are some litigation trackers. They're not all that easy to use. There's one, if you go to justsecurity.org, you'll find their litigation tracker. I will try to find our own litigation tracker, which is a bit simpler because it only deals with the labor cases that are going on, whereas Just Securities is all the cases against the administration. So you're going through national security and environmental, et cetera, et cetera. I'll try to find ours and put it in the chat as well. But it's not easy. It is not easy to keep track of this.
And I think that finding these resources and figuring out what's going on is definitely the challenge with with all of this as well. And so I know Shirley, who's producing this just now, put in the Just Security Tracker. So we'll continue to share some resources on those as we find them. Oh, another question, moving on resources, but a question that I'm seeing in the chat is very quickly, we've talked about MSPB appeal rights. Folks have a question if they can file an MSPB and an EEO claim concurrently around their RIF.
So there are such cases that involve both personnel actions challengeable for the MSPB and claims of discrimination that the EEOC would handle. I'm most familiar with mixed cases where they're alleged in the same kind of case, and there's a special process that applies where cases are heard both by the MSPB and the EEOC. I'm not sure, and I don't know if Rushab or Deborah have information on how they would handle it if you filed separate complaints. But I know that you can bring what's called a mixed appeal to the MSPB that also alleges claims of discrimination.
Yeah, Robin, I wouldn't feel comfortable talking about that in the RIF context because I haven't worked on one of those myself. So I would, I think that's something we would have to, you can ask your union, or maybe we can get some resources at a later date on that, on those mixed cases and how that would work with a RIF appeal.
And I think that's always my advice for folks asking these sorts of questions is go talk to an attorney or go talk to, union or other resources. So always a good thing. I know some folks are asking about these cases and whether it impacts them if they get, if they are RIFed and get rehired or get hired someplace else, how this might affect them, or does it impact their ability to be rehired at an agency versus accepting, if they stay in a long-term RIF status versus accepting a no-fault separation package, can they appeal still if they've accepted sort of terms of separation from their agency outside of a RIF? So if they decide to, and I'm going to guess from the question that I'm seeing, like and I think this is more of a clarification, if you took the DRP or the fork in the road, however you want to call it, if you voluntarily left under a VERA or something like that, that is different than a RIF. I think people should understand that. And Rob, you may want to clarify for folks.
Yeah, I mean, I think the individual factual circumstances matter, but I think you should be aware that if you take the DRP, my understanding is there's a pretty broad waiver of your rights that you are asked to sign, which could definitely affect your ability to proceed with an appeal. I think anything that you do that's viewed as voluntary, including taking an early retirement, that could have consequences for an MSPB appeal. Again, like the individual factual circumstances matter. I think another part of your question was, what happens if I get RIFed and I go out and I get a new job and my appeal's hanging out there? That's fine. Like, you still have a legal claim. Like, maybe you want the job back, or if you don't want the job back and your appeal is successful, then you might be able to get back pay for the time between when you were taken off the books and when you were offered a chance to come back. So you shouldn't feel that, oh, I've now got a new job, I'm just going to withdraw my appeal. Like, you can see how that plays out, because you might get a remedy.
Right. And just to follow up on that last point, just to, again, set expectations, because I know, especially, if, you should continue with your appeal, if you were able to find another job. But, just for those people who may be seeking private counsel, who may be, deciding how much time and effort to spend on that appeal as well. One thing to just consider is the MSPB does often have a mitigation principle when it comes to back pay. So, just to be clear, like, again, individual circumstances are going to matter, but, if you, got new employment at another job, and you did eventually win your appeal and you got back pay, that award could potentially be deducted. You could be reduced based on what you made separately. But again, that individual circumstances are gonna come into play there, so you should consult with an attorney. And then one other thing, we've gotten a lot of questions on voluntary separation, so not on the DRP, but voluntary reassignments offered to employees at our units who, basically agencies are saying, you're going to be RIFed, but if you decide to move to this other position, you won't be RIFed. And so, that there still may be a way to appeal, but, it's not, you shouldn't expect, if you take that voluntary separation, there's a possibility that, you won't be able to claim you were RIFed anymore because you weren't, right? You took that voluntary reassignment rather.
I'll just add that tens of thousands of people took Fork in the Road and then the second version. And as Rob said, there are incredibly broad waivers of rights in these programs, where you essentially are waiving your right to challenge anything at any time about these programs. Now, you could argue that these are too broad to be lawful, these waivers, but I'm not aware of any challenges to those waivers. And so I think if you've taken a DRP, that is kind of the end of the road in terms of challenge.
And speaking of sort of challenges and some of these other questions, I'm kind of rolling through all the many, many good questions that we have out there. So appreciate everybody bearing with us trying to get through some of these. But folks have questions about if they think the RIF hasn't been carried out correctly, or if they came across something where positions have been removed through a RIF, but they're seeing them rehired as contractors, or if they're seeing other irregularities, where should they go to flag things that they think are irregularities? And I know some of our sites have whistleblower resources and things like that, but just curious, Deborah, Rushab, Rob, where you would send folks if they think there are like process irregularities in there.
I mean, initially, I'll say, and I mean, I'll say this again, and I think Rob and Deborah would as well. If you're a member of a union, go to your union and ask them, what you may be able, what the information would be helpful to them, and then they can also, our affiliates will feed information to our office, and then we'll work with our partners. I talk to Rob's counterparts in Democracy Forward's legal team multiple times a day, right? And we share information on our things. So going to the union is always a very good first step if you're a member or a bargaining unit employee, or within an agency covered by a union.
I would say if you don't have the union avenue, and I would agree with Rushab that that's where you should start, but if you don't have that avenue, you're in a little bit of an odd situation. Let's say they got the dates wrong. Your RIF notice has to include certain factual information. And let's say they got it wrong. Those are grounds for an appeal at the MSPB, and you might win. However, what is the agency going to do then? They will correct it. They'll correct that mistake and send you a RIF notice that is accurate. And then, maybe you've bought yourself some time for sure, but it's not a permanent fix. I would say in my view, the most egregious error, quote unquote, is the assertion that you've been terminated for poor performance. And I've seen many people who don't want their jobs back, but they would like the record corrected. And that I think is more than worth pursuing in whatever way you can, if you feel that this is going to follow you in your job search.
And I would. Oh, go ahead, Rob.
Just one quick thing. I want to put a cherry on top of that, Jenny. The example of filling with contractors is something to watch out for. Posting new job announcements that are the job that you had is something to look out for. I'm convinced, they've launched this new Schedule G. And are they going to start using that to bring people into the very job that you had? And that would be a brand new ground for an appeal. And it's the same advice. You got your union, you got Rise Up. You can go on civilservicestrong.org. We're collecting RIF notices there if you want us to take a look at it. So all of those places.
Yeah, and that was, I think that's absolutely right. And I was just going to add my usual public service announcement, if you will, of download your SF50 forms, download your, performance forms, things like that, documentation. Deborah, to your point about people having great performance reviews and then getting a RIF notice that is claiming performance grounds. So I just always try to remind people, and I'm sure most folks who are on here have heard it and done this, but download all your documentation so that you have it. It's just a helpful first step. If you got RIF'd and you don't have it already, that's okay. And if you're still able to download it, that's always a good place to start. And Rob, thank you. There's a couple other things that he just put in there that talk you through how to download those things and to get that information. I do know we're getting a couple questions around things like unemployment insurance, financial considerations, all these other things that go with RIF notices. And so I do want to let folks know all of us have some resources and webinars on those, and we'll definitely can do another webinar with our organizations talking about some of those, but just wanted to let people know we weren't ignoring those questions. I will note we are getting close on time here. Oh, I do see one other SF50 question that I wanted to raise up of folks who have been on admin leave and never received an updated SF50. Do you all know if that causes any challenges with them appealing or anything else? It shouldn't if they don't have the documentation. That would all be in discovery potentially. Is that correct? I'm parroting what I've heard.
I think that's right. And I think in the course of that litigation, one of the asks should be that the agency produce the SF50.
So for those of you, again, who don't have it, that's not a stopping point necessarily. But I would like to, knowing that we're getting close on time, ask each of you if there's any other resources that you want to raise or last thoughts on how people should walk away from this particular conversation, thinking about other court cases that are out there, things they should keep track of. Kind of open floor for a last thoughts here.
I can jump in first, Jenny, and just again say thank you and what an honor it is to be with Deborah and Rushab and you in this discussion. We've really only touched the tip of the iceberg in the scope of litigation that's out there. There are specific cases involving the U.S. Department of Education, the USAID, small agencies like CFPB. Like there's so many different lawsuits that are out there, and it is hard to keep track of them all. And then you get into all of the MSPB appeals and everything. And so we're going to keep working as our community to try to help make it easier for you to track all of that. And I think the other thing I want to say about it is, like, if your agency is not represented in a specific lawsuit all by itself, it's just a matter of like what the legal claims are, what the standing is. We have to, demonstrate why we're able to be in federal court in the first place, which, as I mentioned, can be hard for federal workers. So just know that, like, there are lots of organizations that are looking to find the best ways to fight for you, and then also the best ways to make it easier for you to fight for yourselves and be equipped with the information you need. I'm going to drop our "You Are Not Alone" resource in the chat, because that's the message that I want to leave everybody with, Jenny, is you're not alone. We see you, we care about you, we're fighting for you, and we're going to keep doing everything we can to vindicate your rights. And so thank you all for joining tonight.
I think that's a great message. Deborah, Rushab?
Yeah, I guess I would certainly echo what Rob is saying, that you are not alone. At Rise Up, we've had 3,000 workers come to us for the consultation that we provide, which we acknowledge has caused a long queue. Our volunteer lawyers are moving through that queue. And what we try to do is really give you a sense of what your legal rights are so that you can make informed decisions, whether that's hiring a lawyer, whether that's deciding you are covered by a class grievance because you are represented by a union, or you're covered by a class appeal. But we want to make sure that you have the information that you need so that you understand your rights and you can move forward with the decisions you have to make about your life right now in this horribly complicated situation.
I think that's right. And real quick before Rushab, before you go, just our producers are reminding me that we are going to launch a quick poll, just because we know we didn't get through every question. We know people have other topics out there that they want to hear about. So for those of you listening, you'll see a poll on your screen. And then Rushab, back to you for last thoughts.
Well, thank you. And I mean, I echo everything that Rob and Deborah said. And I mean, again, we're doing our best to, as a community and as a union to fight for you on all legal avenues and to provide the support. And so I think, one important thing is to go to your union if you have one, or, if you don't have a union, you can try and organize one. And we can help you with that, or other unions can help you with that. But I also just want to say, I mean, I think, and this is echoing on You Are Not Alone, I think while everything that is happening is terrible, this is a time when everyone understands the importance of your work. And so, no matter what agency you're at, it is, thank you all for doing your work. And, I have been more proud about representing federal employees now than I ever have, because what I hear from all of you is that, you care about your job, you want to fight for your job, but it's not only for you, but it's because you care about what you do, right? And whether that's helping, Social Security recipients, or, helping the world, it's so important. And just thank you. And, again, thank you for letting us support you.
I love that. Those are all great messages. So I hope folks take away some resources, take away those messages that you aren't alone and that we all are so appreciative of what you do. And please let us know what other topics you have so that we can all continue to support you all and answer questions. So Deborah, Rushab, Rob, thank you so much for joining us this evening. That was really, really helpful. And we're already hearing great feedback from folks. And so thank you for all of you and your organizations for what you do. And we will keep continuing the conversation with folks. All right. Have a good evening, everyone.
Thank you.